For years, the public was told to wait, that the documents existed, that the truth was coming, that justice, however delayed, would eventually arrive in the form of sealed folders and classified records finally open to the light. What emerged was more complicated than anyone expected. Not a clean revelation, not a client list, not a smoking gun. What came out instead was something harder to process. A portrait of institutional failure, strategic concealment, in a system that protected itself far longer than it should have. This is what was hidden and what was finally released. The files didn't begin with a single dramatic disclosure. They accumulated over years through court orders, congressional pressure, journalistic lawsuits, and political promises. The first major release came in January 2024, when a federal judge unsealed 4,553 pages from the civil lawsuit filed by Epstein survivor Virginia Giuffre against Ghislaine Maxwell. That release mentioned high-profile names. It confirmed details survivors had described for years, but it revealed little that hadn't already circulated in legal proceedings. The deeper files, the ones held by the FBI, the Department of Justice, and the Bureau of Prisons, remained untouched. Those were a different matter entirely. As of late 2020, the Department of Justice's unreleased Epstein materials consisted of nearly 100,000 pages, along with 40 computers, 70 CDs, 26 storage drives, and 6 recording devices containing a collective 300 gigabytes of data. Physical evidence in FBI possession reportedly included photographs, travel logs, employee lists, blueprints of Epstein's island and Manhattan home, and a logbook of visitors to his private island. None of it was public. All of it had been sitting in government storage for years. Congress moved in November 2025. The House passed the Epstein Files Transparency Act by a vote of 427 to 1. The Senate approved it unanimously. President Trump signed it into law the following day. The legislation gave the Attorney General 30 days to release everything. What followed was a release that satisfied almost no one. The first batch arrived on December 19th, the legal deadline. It immediately drew bipartisan criticism. Hundreds of pages were entirely blacked out. One 119-page document labeled Grand Jury NY was completely redacted. A set of 3 consecutive documents totaling 255 pages contained nothing but solid black. Investigators and survivor advocates had waited years for this moment. What they received was ink. But within the documents that could be read, significant details emerged. One document confirmed that the FBI had been warned about Epstein's crimes nearly a decade before his first arrest. In September 1996, survivor Maria Farmer reported to the FBI that Epstein was involved in child sex abuse. Investigators failed to act on that complaint. That single fact reframes the entire timeline. The 2008 plea deal, long criticized as inexplicably lenient, looks different when you understand the FBI had a filed complaint sitting on record for nearly a decade before it was acted upon. Grand jury transcripts included testimony from FBI agents describing interviews with girls and young women. The youngest person interviewed was 14 years old. One woman who had been recruited at 16 told investigators she had gone on to recruit other girls herself, receiving $200 for each one she brought to Epstein. These were not rumors. These were sworn statements collected by federal investigators, then filed away. In September 2025, Bloomberg News independently obtained approximately 18,700 emails from one of Epstein's personal accounts, spanning from 2002 through 2022. 4 independent experts verified the cache as authentic. The emails showed Epstein in regular contact with academics, financiers, and political figures. They showed a man who operated not in shadows but in plain sight, exchanging casual correspondence with people who had every reason to know his reputation. In January 2026, an additional 3 million pages were released, including 2,000 videos and 180,000 images. The sheer volume made comprehensive review almost impossible. Files appeared and, in some cases, were quietly removed. At least 16 files that had been disclosed were later deleted from the government website where they were published, including a photograph involving President Trump. The question of a so-called client list became the most politically charged thread running through the entire disclosure. The Department of Justice released a memo in July 2025 concluding that no client list existed in the Epstein files, that no credible evidence supported claims Epstein had blackmailed prominent individuals, and that his death was a suicide. Investigators said they reviewed footage from outside Epstein's prison cell on the night he died and found no evidence that anyone had entered the area. For many, that conclusion settled nothing. What the files confirmed, more than any single name or document, was the scale of the institutional failure surrounding this case. These documents revealed the extent of internal government debate about the 2008 plea deal, previously unknown details about how federal charges were avoided, and evidence of failures across multiple law enforcement agencies spanning years. The crimes were not invisible. The complaints were filed. The warnings were given. The evidence accumulated. What was hidden from the public was not simply a list of names. It was the record of a system that looked directly at what was happening and chose, repeatedly, to look somewhere else. The Department of Justice stated that its January 2026 release would be the final one and that it had met its legal obligations, despite acknowledging that as many as 6 million pages might qualify for disclosure. Whether the full record will ever surface remains uncertain. What is not uncertain is this: the files exist, the complaints were made, the system was told. And for nearly 3 decades, the answer from the institutions trusted to act was silence. That silence is now on the record, even if most of the record is still blacked out.